What's up, everybody? Stephen Lefkoff here, Lefkoff Law, and I wanted to bring to your attention a recent case decided by the Supreme Court of Georgia on February 10th, 2020. Presiding Justice David Namias issued an opinion in Cohen versus Apteen, Inc., which was a really fascinating case that the Supreme Court took up to discuss whether punitive damages are allowed in abusive litigation cases. I wanted to talk briefly about the history of the abusive litigation statutory tort, as well as what the Supreme Court decided in somewhat of a landmark ruling that might have a little ripple effect when you're dealing with cases that involve abusive litigation and the potential consequences for pursuing cases that are abusive in nature. In 1989, the Georgia General Assembly created the statutory tort of abusive litigation. They defined it as follows: a person who takes an active part in the initiation, continuation, or procurement of civil proceedings against another shall be liable for abusive litigation if such person acts 1. With malice, and 2. Without substantial justification. That was codified in OCGA section 51-7-81. That tort expressly replaced all other abusive litigation torts except OCGA 915-14, which I'm not going to get into, but it's a whole different abusive litigation tort. The damages are what become interesting in this case. To the damages available in the abusive litigation case, OCGA 51-7-83 says, a plaintiff who prevails in an action under this section shall be entitled to all damages allowed by law as proven by the evidence, including costs and expenses of litigation and reasonable attorney's fees. And the question became, does all damages allowed by law include punitive damages? Especially given the caveat there, or the specificity of the statute, to say including costs and expenses of litigation and reasonable attorney's fees. In fact, one of the things the defendants argued in this case was that since the legislature included that language, including costs and expenses of litigation and reasonable attorney's fees, they, by doing that, limited the statutory language itself and limited how much or how the damages can be awarded in an abusive litigation case. Because otherwise you just say all damages, right? Wouldn't all damages include costs and expenses of litigation and reasonable attorney's fees? Why does that language have to be in there specifically? The Supreme Court addressed that argument by saying historically that was a questionable area of damages allowed in a case. Okay, so historically speaking, costs, expenses of litigation, and reasonable attorney's fees weren't always a given. So to avoid any confusion and to avoid any risk that that wasn't included in, quote, all damages allowed by law, the Supreme Court said that the legislature included the language including costs and expenses of litigation and reasonable attorney's fees. Had they not included that language, there was some risk that the Court of Appeals or the Supreme Court of Georgia would at some point rule that those damages were not included in an abusive litigation case. So to avoid that risk, the legislature included that specific language. So what the Supreme Court of Georgia really focused on in this opinion, besides they went through a number of pages of just backstory and why and how and kind of history, which is really fascinating, but I'm not going to go through it because it would take half an hour, frankly. But what they really focused on is what's included in the language all damages allowed by law. The defendants, in their argument also, besides this issue with the specificity language later on in the statute, also said that there's statutory language in other statutes, other areas of the law, where the legislature included the phrase any damages sustained. And historically, the Courts of Appeal and Supreme Court of Georgia have ruled that where any damages sustained is in the law, it does not include punitive damages, because punitive damages do not qualify as any damages sustained, right? It's important to understand why we have punitive damages, and I'll go back a minute to a little history on that. So punitive damages are awarded to punish bad behavior. They are not awarded to reward a party or to compensate a party in any way for success at trial or for damages they've incurred. Punitive damages are awarded to punish for bad behavior. Where do you see this? In a lot of cases, you've probably read news articles about injuries, right? Injury matters, or class action cases, or other cases where you have massive damage amounts. And you say, wow, how did that case get $300 million, right? That doesn't make any sense. It's maybe somebody, God forbid, passed away, or even less, right? Maybe it's a broken leg, and you're like, a broken leg, $20 million for a broken leg? How is that possible, right? Because the number itself that you read in a news story, or I read in a news story, or anybody else sees flash across our TV screen is a shock and awe kind of number, and you say that can't be, right? Well, that number includes punitive damages. The actual injury itself, the broken leg, the dislocated arm, the whatever damage that might be, there's a cost associated with that, right? There's some piece of that that's hard to quantify, right? There's a pain and suffering element. There's stuff that we don't exactly, you can't punch into necessarily a formula. But there is a formula for some of it. How much did it cost for the surgery? How much did it cost for the rehab? How much did it cost if you had to repair your car after a car accident, right? These are dollar amounts. But those costs, we all know, it doesn't take, some kind of very, very high up economist to figure this out. Those costs cannot possibly equal the millions of dollars of damages that we read about in news stories as awarded in some of these cases. So where does that balance come from? It comes from punitive damages, which are awarded to punish the bad acting party. Okay, so let's go back to the case we have here with us now with the Supreme Court of Georgia. So all damages sustained does not include historically punitive damages, because punitive damages, like I just went through, are not sustained by the party. They don't incur punitive damages. They are meant to punish. But all damages sustained is not included in the Abusive Litigation Statute 51781. That statute says all damages allowed by law. Punitive damages are a damage allowed by law. They may not be sustained, but they're allowed by law. So the Supreme Court said that means that punitive damages are allowed in an abusive litigation case. So it's an interesting opinion. It's a long opinion. It's worth a read if you have the opportunity to find it and to take some time to read it, because it does go through some interesting statutory history. There's one other piece I want to mention before I get off this video, and because I thought it was a really fascinating argument the defendants unsuccessfully made, but made nonetheless. And that's, they said, well, if punitive damages requires a showing of malice, which it does, right? Punitive damages are governed by OCGA 51-12-5.1. And it says in that statute, punitive damages may be awarded when, quote, defendant's actions showed willful misconduct, malice, fraud, wantonness, oppression, or an entire want of care. So the defendants argued that because every plaintiff who brings an abusive litigation claim must show that the defendant acted with malice, right? Under the abusive litigation statute, you have to show that they acted with malice in order to actually recover the punitive damages that the Supreme Court says you might be entitled to, or all damages that can be awarded, right? That they say you're now entitled to under the abusive litigation statute. Since you have to show that it's with malice, then doesn't that mean every abusive litigation case will have punitive damages? Because if you have to show it's with malice to succeed on your abusive litigation case, then haven't you met the burden to show that it's with malice to get punitive damages, right? So you have an issue of double recovery potentially. Not only you're recovering punitive damages in abusive litigation, you're also recovering because you've shown with malice, right? Or even if it's not double recovery, you're at a minimum going to have punitive damages in every single abusive litigation case, which exponentially, as we talked about before, raises the amount of damages. That was the defendant's argument. So they were arguing, listen, you can't have punitive damages in abusive litigation because it's the same qualification that you have to meet to get it. So if you're going to allow punitive damages in abusive litigation, you're going to always have punitive damages in abusive litigation. That was their argument. The Supreme Court said, no, we disagree. And the reason we disagree is because many statutes don't allow punitive damages in those cases. Okay, so it says, I'll quote from the opinion itself, this argument clearly fails with regard to abusive litigation actions in which the plaintiff seeks damages only for injury to peace, happiness, or feelings under OCGA 51-12-6, because as noted repeatedly in this opinion, punitive damages are expressly disallowed in such cases. So, are punitive damages allowed in abusive litigation cases? Yes, they can be. However, they're not necessarily allowed in the underlying case itself, so you don't end up in a double recovery situation. Once again, this case is Cohen versus Apteen. That's C-O-E-N, and Apteen is A-P-T-E-A-N Incorporated. The Supreme Court site is S18G1638. The Westlaw site is 2020 WL 609656. Since the case was decided so recently, it has not yet been officially reported, so I don't have a Southeast Second or a Georgia Supreme Court citation for you at this time, but it's an interesting case where the Supreme Court of Georgia just last month, just a few weeks ago, ruled that punitive damages are allowed in an abusive litigation claim. I'm Stephen Lefkoff with Lefkoff Law, and that's today's Supreme Court update.